Welcome once again to Lehto's Law. Here's Steve Lehto.
Sheldon sent me a note, so Steve, check out this story from Canada. And this could happen here, but I've never seen an example quite this extreme. So this is from the CBC, and Erica Johnson, Kimberly Ivany wrote this. Customer who filed complaint against a bank refuses to sign gag order to get compensation. And the amount of money that this started over was $1.50 Canadian. But increased use of non-disclosure agreements is a worrisome trend, says a lawyer up there. And understand this. This is important to understand. We've talked recently about non-compete agreements where, you're working someplace. They say, hey, to work here, you've got to sign this document saying you'll never go work for a competitor, for example. And this, however, is a little different. They say, well, we'll settle a case with you. We'll pay you some money, but you got to promise never to tell anybody that we did this. And by the way, some people are bound to ask, what about for your tax purposes? It'll often say you can disclose it when required by law, obviously. But you can't just go out and run around and tell people about this. So the man was poring over his bank statements back in March, preparing to pay his taxes, when he noticed a $1.50 fee for sending an e-transfer, which surprised him because when he opened the account a few years ago, his advisor told him the plan included 5 free transactions a month, and he had never gone over that number. So he complained, and eventually they said they'd reimburse him for the fees and compensate him for his frustration and inconvenience. When the paperwork arrived for him to sign, it included a condition saying he must keep it confidential. While he could speak about the dispute, he would not be allowed to tell anyone that he'd been offered compensation. Now, it turns out that they'd offered him, I believe it was $100. So he'd get his $1.50 back plus, $98.50, if my math is correct, for his troubles. And he says, I was really stunned, to be honest, because I didn't do anything wrong. Why do you try to shut me up? So he emailed the bank to say he would not take the offer if they didn't drop the gag order. And they said that the offer was final, take it or leave it, to which the man said that is just unfair and it's unethical. Now, nobody in Canada tracks how often confidential contracts are used. They're often called non-disclosure agreements, or NDAs. The contracts, typically signed by parties, were initially created to protect trade secrets or intellectual property, but have evolved into a common tool to silence people who've been wronged in all manner of ways. And by the way, these have been around for a while. This is not new. The widespread use of it in an absurd example like this, yeah, that might be new, but I've been hearing about this for quite some time. So a group that campaigns for legal changes related to misuse of non-disclosure agreements is called Can't Buy My Silence, estimates that 95% of civil suit settlements in Canada now include one. Those range from lawsuits over bad investment advice to insurance claims, real estate disputes, building and construction defects, and sexual harassment cases, believe it or not. Now, I've encountered them before in a lemon law case where a manufacturer says, we'll buy your client's car back from them, but they can't tell anybody how, details of that went down. And the strange part about that is that the way the case is resolved, it's spelled out in the law. You take the car back, my client gets their money back. So I'm not sure why that would hurt anybody to disclose that. And on a few occasions, I've told them, no, my client doesn't want to sign that. But quite frankly, it's stupid to insert it here. So I've seen some law firms that just do it in everything they do because they just figure, why not? But I can also see it in some contexts where the fear is that if we let this person talk about what happened to them, everybody else is going to want some. And the question is, how many people are out there, as we say, similarly situated? So trying to keep people silent about almost anything is a concern to a lawyer there in Toronto, they asked. She said it suppresses freedom of expression. She says about 2 decades ago, almost none of her colleagues reported dealing with confidentiality agreements. Today, she estimates 80 to 90% of lawyers she works with say they see NDAs all the time in many areas of the law. So after the media got involved here, the bank apologized to the man in a phone call which he recorded. Spokesperson said that his concerns had been reviewed further, and that he no longer had to sign the NDA. When questioned why they were backtracking, a spokesperson said the agreement was purely for documenting, which makes no sense. You can document it with or without the NDA. In an email to the media, a spokesperson said the bank did not believe that the man should have been required to sign a settlement and release document in this matter. Now, the settlement and release document doesn't strike me as too much because, and by the way, I know a lot of people here have not been involved in litigation. So if you've never sued anybody or never been sued, congratulations. That's the best way to go through life. There's a joke that there's an ancient curse. May you be involved in much litigation, because no one wants to be involved in litigation. However, when you settle a case, it's not just a handshake and they hand you money. There's documents to sign, a release document. And the release is called that because if you're the plaintiff chasing somebody else, you're releasing the other party from your claims. And you usually document that to make sure, number one, it's easier to prove. You can put something on the record in court, but it's almost always followed up with a document, because I've seen before where somebody thinks they've got the right to sue somebody and they've already released their claims against that person in previous litigation, for instance. And so to make sure that someone doesn't come back into court and say, I want to sue that person, the other side says, excuse me, but we've got a release they signed. Judge looks at it and goes, okay, looks to me like you've already released these claims. And so the settlement and release is a document, but it almost always is written quite expansively. And so I've seen them quite simply where it's a single page. I've seen them where they're 4 or 5 pages long. And they'll often have language in there that says, like, for instance, you can no longer sue this person or any of their successors or heirs or, every possible variation of what could happen to this, company. What if you sued Chrysler back when they were Chrysler and then they became Daimler Chrysler? Can you sue them now? They're a different entity. So they got to cover that. But also, they'll often say things like you can't sue them for anything arising out of the transaction involving, like, say, this automobile. And I remember a guy who was an attorney for Chrysler, and he'd actually say that you cannot sue my client when he'd describe who they are. And then he'd say, for anything to do with this car, going forward to the end of time and going backward to the beginning of man. And I used to ask him about that. I go, is that really necessary? And he goes, well, if you're going to pick a date, right? I go, yeah, but you could say going back to, like, say, 1800. And he goes, but that would look silly. I said, yeah, but doesn't till the end of man or the beginning of time look silly also? He said, what are you going to do? So it turns out that NDAs are coming under legal scrutiny, especially in Canada. In 2021, Prince Edward Island became the first jurisdiction to pass a bill to limit the use of NDAs in cases of discrimination and harassment. And other provinces have likewise introduced similar bills. And that's a concern people have, because something will happen, it'll hit the news. Something horrific happens. And people go, oh my gosh, I can't believe that happened. And then somebody raises their hand and goes, well, it happened to me a few years ago, but I approached them, we settled, and I signed an NDA. And then people say, wait a second. If you hadn't signed the NDA and you had publicized your situation, maybe these later people wouldn't have gotten hurt. And we've heard of a bunch of cases like that lately. And that's the scary part, where somebody comes forward and says, yeah, it's been going on for a while. And I can think of several examples of that, where people looked back on it and said, maybe these NDAs should not have been there. But when you're a victim of something and someone offers you to settle in a way that will make you financially okay, and they say, oh, by the way, you can't tell anybody about this, then it's kind of like a difficult bargain to consider. So this one is unusual because it started out over $1.50. Like I said, I think they offered him $100. I think it was $100 they offered him for his aggravation, but that included his $1.50 back. And he said, no, I'm not going to sign this. And then he went to the news with it. And so now, of course, it backfired on the bank. So there you go. Sheldon, thanks for sending it from cbc.ca. Erica Johnson and Kimberly Ivany wrote that. And NDAs generally are enforceable in America also. It depends on the state, depends on the subject. There are some areas that are now saying, hey, an NDA in this field won't do any good. And some people might say, Steve, what if the other side had committed a crime? And I get subpoenaed. Again, it gets back to the NDAs will often say that you are allowed to release the information when required to do so by a court. Okay? So a judge calls you to the stand after a party has requested it, and you are sworn, and they start asking you questions. You can't say, "Oh, I signed an NDA." Watch how fast the judge says, "I don't care. Start talking." And that would be something absolutely fine. So there are going to be some exceptions like that, but there is just the bigger question of, a public policy issue of victims of serious things being asked to sign NDAs, and then other victims getting hurt after that who could rightly ask, gee, maybe if you hadn't signed the NDA and had told some important people about this, perhaps I wouldn't have gotten hurt. And that's the real question I think some people have. So it's another question. So again, from the CBC, and Sheldon sent it. Thanks a lot. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Be like a postage stamp. Stick to one thing until you get there.